Please enter your access code followed by the pound or hash sign. To enable audio controls, please enter your audio PIN followed by the pound or hash.
Is FTR on now?
Okay, Judge, everything should be there.
Okay. All right. I really apologize, everyone, for the delay. I have no reasonable or rational explanation for it other than it is. All right. This is the time set for a return hearing on an order to show cause in CV 2017-055490. Starting with plaintiff's counsel, can you please announce?
Good morning, Your Honor. Bryan Eastin on behalf of the plaintiffs, Donna Johanson and the estate of Gary Johanson.
Thank you. Go ahead, defendant.
Nicholas Casavelli.
And Nicolina Casavelli.
Okay, thank you. There are a number of issues pending in this case. We're here on a return hearing regarding attorney's fees, but I also want to identify there are many motions pending, many of which are fully briefed. So I want to review what I understand is pending, and I'm really actually prepared, having reviewed everything. I realize there are some that are still pending briefing. So I'm going to try to identify what I believe is fully briefed, okay, and then I'll let the parties let me know if I have it accurately. And I have reviewed the entire docket. I've familiarized myself with the case. Pending is defendant's motion for clarification. It is fully briefed. I am prepared to address that today. Just so everyone understands, I read everything. I don't need you to reiterate what's in the written material. It's only if you think you have something to add. I take one issue at a time. If you're not speaking, mute yourself. But I believe that issue is fully briefed. I have the second item that I have pending is the defendant's motion to dismiss. I do have a response. I don't believe I have a reply yet, so I don't believe that's fully briefed. Correct me if I'm wrong.
No, Your Honor, it needs a reply.
Okay. All right. Thank you. So I won't discuss that today. The third motion, and this is not any particular order of importance. This is in the order that I've prepared these. The third motion I have, and I do believe it is fully briefed, is plaintiffs/counter-defendants' motion to dismiss the defendant's consumer fraud, accounting fraud, breach of contract, libel, slander, related expenses, counts of, and third amended answer and counterclaim. I believe that is fully briefed. Is that correct?
Yes, Your Honor.
Okay. The fourth item that I have identified, and I do not at this point believe I have a reply, but I'm going to check, is defendant's motion to dismiss plaintiff's fraud on the court. I have a response, and I don't believe I have a reply. Is that correct?
Correct, Your Honor.
Okay. So that's not fully briefed. The next motion that I have pending is, let's see, the motion, defendant's motion to compel. I have the motion and I have the response or reply is pending. Is that correct?
Correct, Your Honor.
Okay. Final and last matter is a motion for summary ruling by defendant, which I'm denying outright. Okay? So I'm ruling on that right now. That's denied. All right, so we really have, of the pending matters, in addition to a return hearing, we have the motion for clarification and the third motion that I identified, which was the motion defendants, no, it was plaintiff counter defendant's motion to dismiss. Those are ripe for ruling. Is that correct?
That is correct, Your Honor.
Okay, I just want to make sure because I know that there are a number of items still pending, and I want to be able to manage what is ready to go. On the return hearing regarding the attorney, motion, the return hearing on the attorney's fees, I'm going to turn to plaintiff first to talk to the court. So go ahead.
I assume you're talking about the order to show cause.
Yeah, this is on the order. This is what precipitated the first part of this court setting, and then the motions. I always identify what's pending or ready to rule on when I set oral argument. So go ahead. Okay.
Well, it's very simple, Your Honor. The court ordered or awarded attorney's fees to the plaintiffs on over the fact that the defendants repetitively filed a motion seeking to disqualify plaintiff's counsel. The court finally said after about the sixth attempt that no, you don't get to do that.
I'm familiar. Yeah. Is there anything else you want to add?
Well, I would just add that they still have.
I'm the judge who issued the final order, so I'm familiar. I reviewed the entire docket, so I understood what I was doing when I issued that order.
Very good, Your Honor. So I guess the only thing I would add to that is that order did contemplate that the defendants were to pay that amount into the court, and still, as far as we know, that has not been paid since the deadline, I think, was in the end of June. And since that date, we still have not seen that paid in or been notified. So it's still delinquent. The defendants are still in contempt of this court's order, and we would ask that it would be ordered that they immediately pay it and even be responsible for the additional costs for having to bring the order to show cause.
Okay, and at this point, before I could hold somebody in contempt, there would have to be an opportunity to be heard, either through an evidentiary hearing or argument. So I'm going to turn to you, Mr. Casavelli, and you need to understand, sir, I've reviewed the entire docket. I did that before I issued the order that's now in dispute regarding the attorney's fees. So the issue isn't whether or not the attorney's fee award is justified. I made that determination and I issued my order. The question is there a good cause or reason why you failed to comply with the court's order? That is the only issue that we're talking about right now.
Your Honor, he renewed the motion to get the attorney's fees. It wasn't a sixth attempt to remove. We objected to being sanctioned for doing.
Mr. Casavelli, you have to understand something. I'm past that. I issued an order that was based on prior proceedings. I understand I rotated into this calendar, but I reviewed the entire docket. And I'm not a court of collateral appeal. I'm a trial judge that has inherited this calendar. So when you're unhappy with something, that's something you'll later take up with the Court of Appeals, not with me. And if this is a veiled motion to reconsider, that's denied. So I tried to frame the issue as clearly as I could. I issued the order. The only question now is not whether it was meritorious. That goes up to the Court of Appeals. If you have some legal basis to challenge it, that's not me. That's done. The only question before the court is whether or not there is a good cause reason for your failure to pay the attorney's fee award.
Well, I guess it would be paid if Mr. Eastin had not removed our income 2 years ago.
Well, if there is some payment schedule you want to negotiate, I don't know that Mr. Eastin is interested in that. I don't know that anybody's ever discussed that. I don't know, Mr. Eastin, whether you would be interested in negotiating a payment schedule that then there has to be compliance with, because if there's a true inability to pay in a lump sum, that might be a good cause reason. And just so you know, Mr. Casavelli, that's when you file a motion to the court not to get out of the award against you, but to ask for relief in terms of paying it in a lump sum, or in the alternative, that's when you call Mr. Eastin up and explain you might not have the financial resources to pay it in a lump sum. Will somebody be willing to set up a payment schedule, with or without interest? Those are things that get negotiated. But what is not negotiable right now is I issued a lump sum award. So if you're telling me you cannot afford it, then we would have to have an evidentiary hearing where your finances are then examined to see where money can come from or why you're unable to afford it. And the amount we're talking about is $2,368.70. That was the sum that was awarded. So
I'm not going to do either one, Your Honor, because my finances aren't open for discussion on this. The award was unjust, and I don't feel that it's deserving. That we should have to pay for this.
Sir, we're going to stop right there. There's a big difference between you indicating that you feel the award was unjust. That goes to the merits.
Conspiracy?
So do not interrupt me. I want to really, sir, I mean it when I say that. Do not interrupt me. I will give you a chance to talk. You need to understand there is a difference between your view that this is an unjust award. That goes up to the Court of Appeals. That's a statement that you think the court is wrong. That's an appellate issue. Versus your statement that you did not have the financial resources or you were unable to pay. Those are two different issues. I am not interested in your statement that it's unjust. Take that up with the Court of Appeals. I am solely interested in why you have failed to comply with the court's order that you pay that sum. Now, if you are unable to pay, and that's a statement you've made, then your financial resources and ability to pay are subject to review by the court and by plaintiff's counsel, because that would be a potential good cause reason to relieve you either of a lump sum payment or somehow negotiate how you're going to pay it. I would be very interested in that, but I do not want to hear another word about this being unjust. That statement, I'm not listening to that. So I'm going to put a direct question to you again. Are you able to afford, not whether you like it or not, are you able to afford to make a $2,368.70 payment in a lump sum within 10 days of today's date? It's already past due. The answer is yes or no.
No.
Okay. So and Miss Castelli, is that your last name?
Yes.
Okay. You're also a party to this. So if you are unable to pay, then that is something that allows the court and plaintiff's counsel to consider your financial wherewithal as a good cause reason to view alternatives to how this award of attorney's fees can be handled.
We have not been working.
What kind of award?
So I'm not talking to you right now, Mr. Castelli.
Could you repeat that, please?
Yes, I'm going to talk to Ms. Castelli. Ms. Castelli, I perfectly understand that Mr. Casavelli and you, I'm going to join you in that statement, do not agree with the court's order. That I understand, duly noted and overruled. That's something you would take up with the Court of Appeals. The question for the court on this return hearing on the order to show cause is why you didn't make the payment. And my understanding, Ms. Castelli, is you do not have the financial wherewithal to do that. Is that correct?
Correct. We lost our business. COVID-19 has everybody in the country out of work, including us. We haven't worked in a very long time, and money is very scarce for everybody, including us.
Okay, well, and I don't mean to probe without your ability to defend yourself, and Mr. Eastin has this opportunity. There are some people who aren't able to work because of COVID and who lost their business but actually have assets and resources, and that's the type of information that would be available to the court and Mr. Eastin in determining whether or not there is a good cause reason for the court to work with you on this $2,368.70 award. So it's not enough to say you don't have the financial resources because you lost your job because of COVID, because that's not the end of the inquiry necessarily. It could be, but it may not be. Do you understand that?
Yes, but to be honest with you,
they're going to do what they're going to do.
This lawsuit has cost a lot.
Let them do what they're going to do.
It has cost a lot.
Okay, I understand that. Mr. Eastin, are you hearing this conversation?
Yes, ma'am.
We're not opening our finances.
Mr. Casavelli, I'm not talking to you right now.
Okay.
At this point in time, I'm going to shortcut it. I need to set a hearing on the issue because either they have the financial resources or they don't. Either they're going to comply with discovery requests regarding financial resources or they're not. I don't know the answer to any of that right now, but I'm not going to discuss the matter further. They're, at this point in time, subject to the court's order. The court is not relieving them of the obligation until and unless a good cause reason is shown. I don't think we have to set aside a tremendous amount of time, but there may have to be some disclosure. Is setting a hearing for, what do you think, an hour in about 30 days adequate?
Yes, Your Honor. As far as plaintiffs are concerned, yes.
Okay, and Ms. Castelli, you have to understand what this entails. By making a decision that you don't have the financial resources, that you're attempting to establish you have a good cause reason for not complying with the court's order. By saying that, that means, I just want to be as plain as day right now, that Mr. Eastin can make inquiries into your finances and say,
No.
Okay, so he's done this enough. Stop.
He's done this enough. And this goddamn word is he's not getting it out.
I need you to mute your phone. I'm not.
Mr. Eastin has gained our records illegally. We do not feel comfortable giving him any more than he's already gained.
Okay, so if your decision, and I do not want Mr. Casavelli to address the court again. I'm only going to talk to you, Ms. Castelli.
Why? You're restricting my rights?
He's hurt
right now. Right now, you're not ever speaking to me or anybody that's a participant in this court proceeding or my court staff the way you've just talked to me on the record. That's not ever happening again.
You do not understand what he has done.
I just said don't talk. I wasn't joking. So, Ms. Castelli, what you need to understand is by making a statement that you are not willing to undergo the necessary discovery to establish your good cause reason, I'm going to stand by my order. Do you understand that? Which means that there is an order that you pay the $2,368.70, and because of your refusal to participate in the hearing to establish that you do have a good cause reason to relieve yourself of this obligation, I'm going to affirm my order. Is that part clear to you? And I'm only addressing this to Ms. Castelli. Ms. Castelli, are you understanding what I'm saying?
No. I don't understand how this has gotten to be this way.
You can't have it both ways. You cannot say that you cannot afford to pay the amount when there's an outstanding court order, but be unwilling to establish why you can't pay that amount. It's that simple.
Which means I have to give him what little finances that we have he's got, or not have. Come on, he hasn't been working.
It isn't just about him. You have to present.
You're right. He's trying to destroy us in every way possible, and this is just another way.
This has nothing to do with that. There's a court order. You have violated the court order, and you are saying you have a good cause reason. You now have to establish that you have a good cause reason. So
we will get
to set a hearing. I'm setting a hearing. I'm not talking about it anymore. I'm setting a hearing, and at this
time,
I'm going to set a hearing. You can either cure the problem by paying the amount or attempt to establish that you do have a good cause reason for avoiding the award of attorney's fees. Stop interrupting me. I am also going to set oral argument on all the other motions. By then, they will all be fully briefed at that time and try to take care of everything at that time. So I'm going to set aside 2 hours for that. And just give me 1 second to find time on my calendar to do that. That would be where I could have time to do it. I'm looking at my calendar, and right now the best day for me, unless my staff says to me absolutely under no circumstances, because right now I don't see anything on my calendar on that day, but there may be a reason for it. So, Crystal and Alicia, if you're hearing me, I'm looking at October 15th. Tell me if there's a problem with setting it on October 15th.
I don't see a problem, Judge.
Okay. All right. October 15th, I'm going to set it at 9:30 a.m., and I'm going to set aside 2 hours. And it will be for all the pending motions for oral argument and an evidentiary hearing on the good cause reason for the defendant's failure to comply with the court's order on attorney's fees.
So you make up your mind before we even have this hearing? That's what it seems like.
No, what I'm telling you is that is your actual opportunity to present the evidence as to the good cause reason. Don't interrupt me. The good cause reason why you have not paid the attorney's fees. It also does mean that Mr. Eastin is permitted to get discovery and make requests regarding that information, and I need that information. And it will also be oral argument on all pending motions. And I'm just going to set aside from 9:30 till noon, and that's what we're going to do. And I'm not going to talk about it anymore. And you are permitted to negotiate with Mr. Eastin if you would like to see if you all can resolve this. But right now, the court is affirming its order until and unless there's a good cause reason established. And I'm not talking about any of the other matters at this time. And we're going to be at recess, and I just want to remind everybody when you're addressing the court, opposing counsel, court staff, or anybody in my courtroom, you do so with full respect and dignity. I will not tolerate raised voices. We're at recess.
All right, that goes both ways.
I'm not talking anymore. We're at recess.
You still nothing to just